Good afternoon. This is the meeting of the Sunshine Ordinance Task Force regular meeting for Tuesday, February 24th, 2009. May we have the roll call?
Yes, ma'am. Member Craven?
Here.
Member Craven here. Member Nee?
Here.
Member Nee here. Member Cotton? Member Cotton excused. Member Washburn?
Here.
Member Washburn here. Member Canepa?
Here.
Member Canepa here. Member Johnson?
Here.
Member Johnson here. Member Chu? Member Chu excused. Member Chan? Member Chan absent. Member Goldman?
Here.
Member Goldman here. Member Williams? Here. Member Williams here. Madam Chair, we have a quorum.
Thank you. And as Mr. Restom noted, Chair Chu is not here, so I will be chairing the meeting. There have been a number of agenda changes, mostly continuances. Items 2 and 3 have been continued by agreement of the parties.
That's
Point of order, sure.
I'm here. I'm Donna Levitt.
Please approach the microphone, please.
I'm Donna Levitt with the Office of Labor Standards Enforcement. It was my understanding that the issue of granting a continuance was something that you had to vote on here and that perhaps I would be able to speak on.
Okay. Chris, is this the one where this is the second request by the complainant? Okay, thank you. You're correct. Thank you for that clarification. So that one will be heard on the issue initially of a continuance. Items 4 and 5 have been continued at the request of the anonymous complainant, and the city has agreed to that continuance. At least that was my understanding from Mr. Restom. If there's another point of order, please approach.
My name is Matt Dorsey. I'm the Public Information Officer for the City Attorney's Office. As a threshold matter, I wanted to address the issue of the propriety of these being noticed as anonymous complaints.
That's not at issue right now. Okay. My understanding is that your office has agreed that items 4 and 5 will be continued and heard at the March 24th meeting. Is that not correct?
It actually wasn't my understanding until just as I came in. But what I was going to ask was that they be renamed and renoticed and both put over till next month. But I'll wait. Should I wait to take that up?
Why don't you wait to take that up for a minute? Mr. Restom, what is your understanding?
I notified the City Attorney's Office. I sent him an email and told him that the meeting was, the complainant had requested a continuance. Okay.
And under our procedures, items where the complainant is automatically allowed to request a continuance the first time, and that's basically automatically granted. So that matter will be heard on March 24th. Turning to items 6 and 7, I believe that the complainant asked for that matter to be rescheduled to continued, and there was no objection by the department. Is that correct, Mr. Restom?
That is correct, Madam Chair.
Are there any other agenda changes? Seeing none, we can proceed to item 2.
Item number 2 is the determination of jurisdiction. I think we have to go for item number 1 for minutes.
Thank you.
Item number 1 is the approval of minutes for January 27, 2009.
I have several corrections to the minutes.
Member Washburn, are these corrections in the matter of purely typographical, or are they substantive?
They're typographical, but they do change the meeting.
Well, then why don't you go through them?
The really only substantive one is page 5 of the minutes, page 11 of the packet. Middle of the page, Member Craven said the unit could be in violation as if it was not a passive body, and that Ms. Eileen Shields' response did not indicate that it was a passive meeting body. She did not see a violation. Shouldn't that read, could be in violation if it was a passive body?
That's correct.
Okay.
And the word is should be crossed out.
Is and not should also, both of those should come out.
Correct.
And the other 2 are minor, and I'll just pass them over to Chris.
Any other member comment on the minutes? Seeing none, is there public comment on the minutes? Seeing none, public comment is closed. Is there a motion to approve the minutes as amended?
So moved. Second.
Roll call.
On the minutes, Member Nee?
Aye.
Member Nee, aye. Member Cotton excused. Member Washburn?
Aye.
Member Washburn, aye. Member Knebber.
Aye.
Member Knebber, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chu. Member Chu excused. Member Chan. Member Chan absent. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams, aye. Member Craven.
Aye.
Member Craven, aye. Madam Chair, we have 7 ayes.
Thank you. If you could call the next matter.
The second item is the determination of jurisdiction on complaint filed by Vince Courtney against Labor Standards Enforcement for not providing documents related to a wage rate issue.
And for the members' information, the complainant asked for a further continuance. This matter had already been continued once from a prior scheduled hearing. Therefore, it's subject to a vote by this body, and I believe there's someone here representing the respondent who wishes to speak on this issue. First of all, I'll ask if Mr. Courtney happens to be here. Seeing that he's not, I'd invite the respondent up to speak on this issue if she wishes.
Thank you. I'm Donna Levitt, and I'm the city's Labor Standards Enforcement Officer. As such, I manage the Office of Labor Standards Enforcement. I'm present today and prepared to address the merits of this matter. I know that the claimant has requested a second continuance by way of a fax to the task force. The claimant says that they were in an arbitration proceeding with the city today, and that is true. Their arbitration proceeding was held at 18th Street and South Van Ness, and it ended at approximately 3 p.m. They easily could have made it here. I spoke to Carl Bunch, who's the city attorney who represented the city in the matter. He left at approximately 3 o'clock. Everyone was eating pizza. He decided not to eat pizza, and he headed home. I think it will be evident from my testimony that this case is not properly before you, that it's really not a sunshine complaint properly, and certainly not a sunshine violation. And I ask for the opportunity to address it here and move on.
Thank you.
Thank you.
Since this is a procedural matter, I will not take public comment on this issue, but would open it up to a motion or questions from members about whether or not a continuance should be granted.
I move that we continue the matter to our next regular meeting.
A second.
Discussion on the motion? A roll call?
On the motion to continue this to March 24th, Member Nee.
Aye.
Member Nee, aye. Member Cawthon. Member Cawthon excused. Member Washburn.
Aye.
Member Washburn, aye. Member Knebber.
Aye.
Member Knebber, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chu. Member Chu excused. Member Chan. Member Chan absent. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams, aye. Member Craven.
Aye.
Madam Chair, we have 7 ayes.
All right, I do appreciate Mrs. Levitt appearing, and we will hopefully resolve this expediently next month. Thank you. I believe the next item is item 8. Is that correct?
Yes. Item number 8 is determination of jurisdiction made by Anonymous against the City Attorney's Office and Matt Dorsey for violation of Section 67.25 A and B.
Madam Chair, I will have to step out on this case, and I'm being replaced by DCA Sanchez.
Thank you, Mr. Lorente.
Members, I move that we find jurisdiction on this item.
Second.
It's been moved and seconded that jurisdiction exists. I believe there's no dispute as to jurisdiction unless either of the parties wishes to speak to the narrow matter of jurisdiction. We'll take a vote and move on to the substance.
Is this others public comment?
This is on the issue solely of jurisdiction of this complaint. We will have a debate on the substance after.
I just want to say, whether it's procedural or not, if it's agendized items, there's public comment on every item, right?
If you wish to have public comment on the issue of jurisdiction, which is not being contested by the parties, please do so. Seeing no public comment on the issue of jurisdiction, please call the roll.
On jurisdiction, Member Nee.
Aye.
Member Nee, aye. Member Cawthon. Member Cawthon excused. Member Washburn.
Aye.
Member Washburn, aye. Member Knebber.
Aye.
Member Knebber, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chu. Member Chu excused. Member Chan. Member Chan absent. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams, aye. Member Craven.
Aye.
Madam Chair, we have 7 ayes.
Thank you. Now turning to the substance of this item, the complainant will have 5 minutes.
Prior to starting my time, I explained to Mr. Rustum I'd like to make a clarification. The agenda and the complaint itself are strictly on the matter of the timely response. The reason I mention that is the memorandum to the task force from the city attorney listed a number of other issues which I do not intend to pursue at this time. I do reserve the right to pursue them at another time. This is only regarding the immediate response.
Mr. Rustum, if you could please start the time. This is part of your presentation. Please continue.
On the January 12th, I placed an immediate response request for the attorney work timesheets for Deputy City Attorney Ernest Lorente with the City Attorney's Office. It was an immediate disclosure request, and it was ultimately received on February the 5th, which is 3 weeks later. First thing I'd like to mention is that the copy I received, it was 446 pages, but if you look at the copy that I received, every single page has printed on the bottom of it January 13th, 2009, which is the day following the date of the request, which would seem to indicate that it was completed on the day of the request at 1:52 in the afternoon and then sat on for 3 weeks. But leaving that as a point aside, I'll go on to the next point. Of this 149 pages, one of the things to first notice is that the City and County Index of Records for the city says all timesheets are maintained online. So this was an online process in a database. There were 149 pages. 136 of those pages either were totally redacted, in other words, they had every single item in columns removed, or they had no redactions at all. That left 10 pages that had redactions on them. And what happened was I was told, number one, we're not going to identify this as an immediate response request. We're simply going to take it as a standard request. So we are going to get a 10-day extension. And then at the end of the 10 days, they said, we're going to take another 14-day extension. And what I'm saying is with the ultimate, you have to take into consideration the ultimate document produced. If what I got was a document with hundreds of redactions, I could maybe technically see this. But it was an immediate response request. It was dated the 12th. I have an indication here that was completed on the 13th. And they couldn't even have the decency to give it to me at the end of the immediate response period time. They simply decided to hold on to it for whatever reason until the 5th of February. Now, one of the things I'd like to bring up is that during this whole process and the response from the City Attorney's Office and Mr. Dorsey's letter to this committee relating to this anonymous issue, he never addresses the issues that I've raised in this instance. He ignores them completely and puts up a bunch of smoke. Basically, all these things about, oh, you can't have anonymous because the city needs to know and the public needs to know, who's filing the complaints, yada, yada, yada. And it seems very convenient that the city attorney's office seems to cite sunshine and public ordinance laws when it's to their benefit, and yet they continually ignore them when it's not. I don't think anonymous is an issue. I think the bottom line is the statement, the form that you have says that if you wish to remain anonymous, as long as there is contact, you may do so. And I think that that is nothing but an issue he is raising. He also raises the issue of the amount of time that is wasted by the city attorney's office in responding to complaints and this task force in dealing with the complaints. Well, that is, I hate to tell Mr. Dorsey, a blame the victim issue. If he simply provided the information that is requested in a timely basis, there would be no basis for a complaint and nothing would have to follow. The city attorney's office nor this task force would have to put any time into it at all. There was another complaint I had on here that has continued till next month, where I issued I sent two requests for immediate disclosure. They were given to me the following day. They were complete and accurate, and there was nothing after that. So basically, if I'm given the information I request, and I'm given on a timely basis, then there will not be any need for a follow-up. So basically, the arguments are specious. There's a whole bunch of statistics and time and energy put into putting forth these arguments when they really have no basis and no reflection onto the simple fact that this was an immediate disclosure request. It was held for 3 weeks before it was finally released, and I can show that basically it was done the day after and not provided even within the immediate disclosure. Now, I know that appearing before this board before, that if I had come here and said, if he had given to me at the end of the immediate disclosure period and said, well, I think he had it earlier, I probably wouldn't have won out. But I don't think there's any excuse for a city agency to simply say, I'm going to ignore the fact that it's a city immediate disclosure request. And unfortunately, dealing with Mr. Dorsey over the years, he has a habit of deciding that he is going to interpret what the law is rather than letting this task force do that. I'm asking at a minimum that he be cited for failing to follow or for violation of that section.
Thank you. The city has, are there any other parties here in support of the complainant who wish to present facts and evidence? Seeing none, the city may respond. You have 5 minutes.
My name is Matt Dorsey. I'm the Public Information Officer for the City Attorney's Office, and thank you for having me. Before addressing the merits of this particular complaint, I did want to address a threshold matter that I think, frankly, has more profound significance to the principle of open government, and that is the propriety of this complaint and the other one being identified as anonymous complaints. It is a matter of public record that Mr. Ray Hartz made the original Sunshine request. It is a matter of public record that he filed this complaint. It is a matter of public record right now on the posted agenda that Mr. Hartz is identified. In fact, I think it's notable that the documents Mr. Hartz provided as evidence in his own case not only identifies his name but also his home address and his personal email address. So at no time has he asserted any kind of privacy interest. This is not a situation in which a complainant is asking this task force to preserve anyone's anonymity. This is a situation in which a complainant is asking this task force to impose it. You know the identity of the complainant. I know the identity of the complainant. Everyone in this room knows the identity of the complainant. Who is being deprived of the information is the general public. And it seems to me that the public has a right to know when they look at the agenda who is filing complaints when they're doing that. And that's what was addressed in the documents that we provided, that there may be reasons. But in any event, we can't decide why citizens may or may not evaluate those documents. The Sunshine Ordinance provides that citizens have a right to a meaningful description of each item of business to be transacted. It defines meaningful as sufficiently clear and specific to alert a person of average intelligence and education who may be affected by the item. So this simply isn't fair. I think it runs counter to the principle of open government and Sunshine that everybody gets to know who the identity of the complainant is, but the public is deprived of that right, the right that they should have. So I would ask that this task force put both items over until next month, that they entitle both complaints properly with the name of the complainant, and that they properly notice them on next month's agenda. I think that would be the fairest thing to do. So, and I actually think this is a really important principle that's at stake.
I would just caution you, unless there's a motion to have this continued by members of the task force, we're going to proceed to hear it. So if you want to address the substance, okay. I would do so.
We identified within 24 hours, in fact, that the immediate disclosure request was not a valid immediate disclosure request. It is true that the document was printed, but I think Mr. Hartz made the case already that there were substantial redactions. It stands to reason that a document is going to be printed first, and then the redactions, which is actually the most time-consuming process, are going to be done. It is simply not the case that the day the document was printed was also the day all the redactions were completed. We went through that. We actually met all the deadlines, and that's all in the document that the city attorney provided. But again, I think it runs counter to the spirit, if not the letter, of the Sunshine Ordinance and the California Public Records Act, that this complaint and the other complaint that's being put over are both improperly noticed, that they're not properly titled, and they should be put over and retitled.
Thank you. Is there anyone here seeking other parties of the city who want to submit facts and evidence in support of the city? Seeing none, the matter is with the task force for discussion and questions.
I have a question for Mr. Dorsey. How long do the redactions take, typically?
It actually, I'm not the one who does them. It's always a job that lawyers do. The basis for doing that would be attorney work product, probably attorney-client privilege, I think would be the one that would be in play for a lot of the timesheets. There can be bases of redaction for personnel records. Sometimes if somebody takes time off, for example, for a doctor's appointment, the fact that it's health related is a privacy interest. So I don't know, and I'm not the person who does that, but it's always something that goes to lawyers. And obviously there were a number of pages that were provided that were responsive to this very large and sweeping request.
So if it was printed on the 12th, then how soon was it ready to give to the member of the public?
My understanding was it was ready when we provided it. There would be no rationale for us to hold it. It was printed. I think, if anything, it shows that we were responsive to the request, and immediately or shortly after receiving it, we printed out the document and then started the process of making sure that this wasn't violating anybody's privacy interest by releasing personal information.
Thank you.
Yeah.
Other comments from members of the task force?
I have a question.
Member Nee.
Yes, Mr. Dorsey, please. You mentioned in your response here, this would be on page 127 of our packet.
I believe that's Mr. Lorente's memo.
Oh, all right.
The Deputy City Attorney Sanchez.
Oh, thank you.
This is from Mr. Laurenti, then?
It's actually from Deputy City Attorney Sanchez because DCA
Oh, I
Lorente
see.
is recused from this site. I misspoke.
Okay. Well, then I don't have a question for Mr. Dorsey. Thank you anyway. But I am curious about something that maybe DCA Sanchez could address. Well, actually, okay. Now, I think it is. This is something that the city attorney's office needs to respond to. Either Ms. Sanchez or Mr. Dorsey or both. On January 27, 2009, the CAO contacted complainant via email explaining that although complainant called the January 12, 2009 request an IDR, on January 13, 2009, the CAO informed complainant that CAO would not respond to it as an IDR because it was not the type of request that an immediate disclosure provision was intended to cover. I didn't realize that IDR requests, that there was some kind of distinction made in terms of what type of material was or was not covered under an IDR. Perhaps some clarification is in order here. In the language of the ordinance, I could find nothing that made that distinction, and maybe I missed something. And if I did, then please set me straight on it. But I think that's a matter that needs addressing.
I had the same question as well.
I can give my opinion, but I'll give it after Mr. Dorsey and Ms. Sanchez speak. Mr. Dorsey, do you want to address why?
Yeah. It is my understanding that the provision in the Sunshine Ordinance that addresses immediate disclosure requests notes that the words have to be there, which they were, but it also says that maximum deadlines provided in this article are appropriate for more extensive or demanding requests. This was certainly an extensive and demanding request. It involves personnel records for a member of the office who has been here for many, many years. So within the time frame allowed, we did respond that it was not an appropriate immediate disclosure request. I guess it wouldn't. Is that answering the question?
Well, I'm still a bit hazy, but maybe between you and Ms. Sanchez, you can clear that up for me.
Sure. It seems like when a request is made of voluminous information, it's so big that it will require time to go through, in this instance, redaction, etc. It is not the type of request that is seen as an immediate disclosure request because it will, by nature, take a longer period of time. Both the Sunshine Ordinance and the Government Code address that.
So you're saying it's the volume of the information requested,
Right.
not necessarily the nature.
And I believe from my recollection of Mr. Dorsey's emails, he addressed that was one of the reasons.
Okay. Thank you.
It's a very fine point, though. In my reading of the complaint and the respondents, what he had to say was that this was a type of information that didn't fall under the immediate disclosure request. And so you're saying it's not the type of information, but it's the voluminous.
I'm not saying that. I'm simply saying what the Sunshine Ordinance and the Government Code say.
Okay. Well,
That's
yes.
clear to
Okay.
see, yeah.
Right.
Yes, Member Williams, I was going to give my opinion, but if you would like to ask a question first.
Okay, are you saying that because it was so voluminous that...
Microphone, please.
Did you let him know in so many words that the volume is so large that we will not be able to get you in a timely manner?
I believe Ms. Williams, they did exactly that. Ms. Sanchez didn't respond. It was Mr. Dorsey.
Mr. Dorsey, did you
Yes.
let
It's
him
in
know
there.
that?
On January 13th, the office, which is with the following day after receipt of the request that Mr. Hartz had labeled an immediate disclosure request, the very following day we informed him that the request was not a, quote, simple, routine, or otherwise readily answerable request, but rather more extensive and demanding. That was quoting the language of the immediate disclosure provisions of the ordinance.
The Good Government Guide, I believe that's what it quotes.
Yeah.
Okay, did you have any response back from him after you let him know that? Was that acceptable to him?
I actually don't recall whether there was a response back from Mr. Hartz. I know occasionally there is correspondence back and forth, but I guess the response that was relevant to this complaint was our response back January 22nd when we invoked an extension of not more than 14 days under the Government Code.
I believe, Ms. Williams, that Mr. Hartz was not satisfied. I think there's some email to that extent.
I have that email. I can read back.
Okay, I don't believe unless Ms. Williams, would you like?
Yes, I would like to hear it. Yes.
Excuse me. If you read the Good Government Guide, I believe you will find that an immediate disclosure request, which this was and is subject to the 14 calendar day extension, while a regular request has a 10-day response window with a 14 calendar day extension. I don't believe that you can have both. In addition, you have not stated in either case the basis for the extension, which is clearly required. Simply stating all of the above is not in the spirit of fair play you always invoke and is not a reason. Why specifically are you invoking this extension? Is it the voluminous nature of the material? Is it the location of a remote storage facility? Or is it the need to consult another party? Again, simply stating all of the above does not show a good faith response. This was an immediate disclosure request. You invoked without a specific reason an extension to that request. You're now invoking an additional extension, again without a specific reason, an additional extension which I don't believe you are long. I will state for the record that our history of interactions has given me absolutely no confidence in your willingness to comply with the Sunshine Ordinance or other public record acts with any degree of good faith. For someone in your position receiving your level of compensation, you act as if you were totally unaware of the public records requirements. It becomes necessary in each and every case for me to continually prod you to act in accordance with the appropriate requirements. Then it becomes a back and forth where you give no direct answer, just nitpicking your responses. Again, from my perspective, a total lack of bad faith.
Thank you.
I'll just briefly add that both my reading of the immediate disclosure provision and I think our experience from the task force is that there are certain types of requests that are appropriate for immediate disclosure requests, and those are, if you read the statute actually, 6725A talks about a category of non-exempt public information. And then it goes on to say maximum deadlines are provided are appropriate for more extensive or demanding requests, but should not be used to delay fulfilling a simple routine or otherwise readily answerable request. So I guess that is in the ordinance itself and in the Good Government Guide. Essentially, my understanding of why this was passed was, if I have a copy of a contract sitting on my desk that I can just copy and give out to a requester, that's appropriate for immediate disclosure request. If, however, I'm going to have to go through 10 different files to pull information, and or if I'm going to have to review that information to redact exempt information, so therefore it's, quote, not non-exempt, it has some exemptions to it, that's going to require more than 24 hours. Nothing in this statute is meant to have a department drop everything simply because a requester calls it an IDR, which is often what many requesters do. There are categories of documents that are appropriate for an IDR, and there are ones that are not. And those can be either as a result of the volume of the information that needs to be collected. I mean, it's not simply volume. Say I have a 500-page document. That's very voluminous. But if it's a contract that's releasable to the public that's sitting on my desk, I can release that within 24 hours. So it's not purely volume, but for example, it could be volume if I have to get different records from different sources, or it's the nature of the information. So it has to be, I have to confer with the city attorney's office to see if it's exempt or not, or what I need to redact or what I can produce. That as well would make it not appropriate for an immediate disclosure request. So that's generally how I read the statute and how I think I've at least applied that in terms of IDRs that have come before this body. So I'm not sure if that's helpful to anyone.
Yeah, thank you.
Is there any further questions from the members?
Yes, I still said, as a personnel matter, I don't see why this should have been so voluminous. I mean, he's asking for personnel records, and we maintain that. And looking at the questions that were asked, I don't see why it should have been that voluminous.
I can let Mr. Dorsey or Mr. Hartz respond to that. However, these are timesheets. And under public records law, the time that an attorney spends on certain matters is not exempt from disclosure, but the descriptions of what they did is. So it requires, and this is what I deal with this on behalf of my media clients as well, unless you have an exemption or a specific reason, those time records are subject to redaction, and the department has to look at those and redact them before they're released. There may be other reasons, such as personnel information, i.e., doctor's appointment or family sick, that may describe something that would impinge on someone's personal privacy rights. I'm not saying there was, but I'm saying that could be another reason for which a redaction would have to be made and review would have to be made. Does that answer your question?
Yes.
Do you have any additional questions?
No.
Seeing none, this is back to the city. You have, if you wish, up to 3 minutes to respond. Mr. Dorsey?
I guess 2 points. One is I understand that Mr. Hartz has been unhappy with me over the years, but one thing I do want to just reiterate, or at least state for the record, because I don't want it to be hanging out there. I take a lot of pride in my profession and how hard I work. If I wasn't committed to open government, I wouldn't be serving City Attorney Dennis Herrera as a public information officer. This is something that actually does mean a lot to me, my professional reputation. I think that if you asked most journalists and most other members of the public, I recognize Mr. Hartz has been unhappy with me, but I think it needs to be responded to when it's an attack. This morning, for example, I received no fewer than 5 emails from Mr. Hart saying that I didn't know the difference between the First and Fourth Amendment, that I'll see you at the task force unless you lose your nerve. It's some things that I think are rather insulting. I really do try to be a professional, and I don't want it hanging out there. This is something that I hope when I see you before, you know that I'm a professional. And then the second thing is I hope you do consider the issue of anonymity of this complaint. This is something where the public does have a right to know, and they have a right to know as much about the city attorney's office and the other agencies that are being complained against as the people who are complaining against them. And this is a situation where it is a matter of public record. If somebody were to send a sunshine request to me asking who filed this complaint, or to you, who filed this complaint, we would be able to provide that information. It just doesn't seem fair that a member of the general public can't look at the agenda and see that also. So I hope you consider that. Thanks.
The complainant has 3 minutes.
The reason I've gotten to the point with Mr. Dorsey that I have is that every single time I try to show good faith effort, I ask him a question as to why he can't respond, why he considers it voluminous, why in one case he has been able to do this, and in this case he's saying he can't. And I get back answers that are basically non-responsive. I also get answers back to inquiries. Basically, the reason I file IDRs is because if I don't file an IDR, I know it's going to be 3 weeks or more before I get it. He's going to take every request, no matter how small. He's going to take the full 10 days, and at the end of the 10 days, he's going to ask for the 14-day extension. And at some point, well, okay, if I don't file this as an IDR, then basically I'm not going to see it for almost a month. And then if it's not responsive, then I have to go another month before I can get a hearing before the board, and it goes on and on. Now, to just basically sum up what I'm talking about this was printed the day after my request in this redacted form. All the redactions were done. And there were only 10 pages out of the 149 that had any individual redactions on them. Everything was either wiped clean or not redacted at all. And to say that that's a voluminous request simply because there are a lot of pages, that's like saying, okay, if it's 500 pages and I redact 499, I can claim an extension because it's a voluminous request, even though what I ultimately provide you is 1 page. And I think that is ludicrous, and I think it is using this to defer. And as the chair mentioned, using these items to avoid giving this information and to delay giving this information is something that I've experienced with Mr. Dorsey over and over and over again. And I didn't say he didn't know the difference between the Fourth and First Amendment. What I said, if he would read it correctly, was I mistyped the Fourth for the First Amendment. So he will take what I say and twist it around. And basically, again, with the city attorney's history of ignoring the rulings of this board, the referrals to the Board of Supervisors, the referrals to the boards of ethics, I have a real hard time swallowing it when they come up here and say, anonymity is hurting the public's need to know. If there's any agency in this city that does more to prevent the public from knowing, it's the city attorney's office. They recommend every city agency not show things, and they do it themselves. But basically, there were actually 10 pages here, and there was some further documentation I submitted that would show you if you sat down at a computer, anybody who knows a database could have done these redactions in less than an hour. And this form was printed on the 19th of January in this redacted form. So, what's to say?
And the matters with the task force for motion and deliberation?
Public comment?
That comes after motion and deliberation.
Oh, okay.
Members, I see that there's 2 issues here. There's the issue that's been called the threshold issue by Mr. Dorsey of anonymity. And then there's the second issue of the complaint, the substance of the complaint that is here. As to the first issue, I find it a very interesting and very perhaps complex issue. because the Brown Act, for example, and as incorporated by our ordinance, provides that a member of a public shall not be precluded from testifying or speaking at a public hearing by requirements to disclose their identity. But it does not speak to, and I have not been able to find a provision that talks about individual who files a complaint or otherwise seeks to petition has a matter pending before a body, and whether or not they are entitled to, when I'm finished, to anonymity on that. I do know that there's a right to petition your government, and there have been cases that have said where that right is jeopardized by disclosing your identity, you can do so anonymously. So, for example, there are federal court cases where immigrant workers who are suing an employer for safety violations have been allowed to sue in an anonymous capacity because to do so otherwise would perhaps disclose their undocumented status to the federal government or to the defendants. So I know that there are certain analogous circumstances to which that applies. I had asked DCA Lorente and DCA Sanchez if they were able to find any additional authority, but it was the request was made today, so there wasn't, I think, sufficient time to delve into that issue. So I do think it's an interesting issue. However, that said, I don't think it's really presented by this case for the reasons that have been discussed. Usually, the initial request itself is the anonymous request, right? So it's the complaint, it's the initiating document, it's the whistleblower. That's when the need for anonymity exists. Here, Mr. Hartz made the complaint with his name in first instance, and then sought to file a complaint with this body based on that unanonymous request before this body. So I actually don't think it needs to be treated as an anonymous complaint, or should be. I mean, the underlying factual information is already there. Had this been a situation where someone made initially an anonymous request and kept the anonymity throughout the procedure and the proceeding, then it would be in a different position. But that's not where we are. So while I think it's a fascinating issue and very interesting, I don't think we need to decide it because I don't think on this case it's presented. That's all I'll say about the first one. Member Nee?
Well, I take a little bit of a different perspective on it. Private citizens do not have the sunshine requirements that governments do. Private citizens have the right to petition government anonymously, and in the case, even when the complainant initially in the initial transactions was not anonymous, it could also be a matter that there was more than one person who had similar transactions, even without anonymity with the respondent, and if one of them then says, well, okay, we all of us here are experiencing the same thing, but if one of us wants to file it, we may be subject to some sort of retaliation if we do it under our own name. So I will go ahead and file this, but I will do it anonymously. I would further suggest that perhaps if Mr. Dorsey wanted to blow the whistle on his own employer for a sunshine violation or an ethics violation or any other kind of a violation, he might want to do so anonymously for fear of retaliation by his employer. So when he says the complainant's anonymity in this manner is at odds with the principle of open government, I'm sorry, I just don't buy it.
Right, and to clarify, I actually agree with Member Nee's comments. My point wasn't we don't need to reach it in this case because it's not really an issue because it's already been disclosed. So, but I do agree with Member Nee's comments. Are there any further comments about either of the two issues, or do I hear any motions? Member Nepper?
I again, I think it's not part of this case, but I do think that this anonymous issue is something that has to be addressed, but maybe not in this form, maybe in understanding the language. I mean, I think I have a different opinion than both of you, but I don't think we need to get into it. But as to what we're doing here. I think that we need to focus on the idea, this immediate disclosure request, and is something that is a, gathered timesheets redacted. Is that immediate disclosure request or not? And if it is, even if it's not allowable, we have both sides saying, I haven't seen the sheet of what the disclosure was. All I have is Mr. Hart saying, or Anonymous saying that this was only 10 pages and it was redacted beforehand, so I can't read. I've already looked through here.
It was 75 pages that was available for.
It looks like Mr. Rustum, could you explain whether or not it's in the packet, and if so, why not?
Excuse me. Because it exceeded the 75-page limit.
Right. And so that basically, where that happens, there should be a notation on the item on the front that there are materials for our review that exceed the page limit. And it looks like that is provided by the double dash on page 124. Is that correct? It's unclear to me whether this form you did for item number 8, the cover sheet, is a standard thing, or if you've actually provided us notification that there was information.
This is a standard form.
Okay, but you must understand that where you're invoking the 25-page rule, you have to let us know that has been invoked. Does that make sense, Mr. Rustum?
Page 138 of the packet.
Okay. Thank you. Right. All right, so thank you. That indicates to us, and I appreciate that. I was neglecting to see that, that there are additional information that hasn't been provided that we are on call or on duty to go look at.
Okay, thank you.
And so again, I will ask if there is a motion.
Madam Chair.
Member Nee.
May I ask Mr. Dorsey an additional question?
Yes.
Yes, Mr. Dorsey, I do have one additional question. Thank you. You mentioned partly, I think, the voluminousness of the information requested. Did you have to go to multiple sources for the information, or was it all available in one spot?
My recollection of it was that there were requests for timesheets, personnel records, and there are multiple offices that one needs to go to.
Okay.
But beyond that, I think the time-consuming thing generally, in my experience, and again, I wasn't the person who did it, it always goes to lawyers, is redaction.
Okay, thank you.
Okay.
I also have a question of Mr. Dorsey. It seems to me that this situation relies, or it turns on a single fact, which is the redaction and when it occurred. And Mr. Hartz is saying that when the document was printed, the redaction had already occurred. And
no, the printed date.
What happened?
The printed date reflects the date that there was a computer printout of the raw data. Mm-hmm. The raw data isn't going to print out with redactions.
Sure.
It would be nice if it did. If there was some way to do that. But the documents come out, and then lawyers have to go through and identify where there's a privacy interest and redact that information.
Okay.
So.
Thank you.
All right, seeing no motion, I would move to find no violation.
Second.
There's been a motion and a second. We will now take public comment.
Hi, members. Kimo Crossman. I think something that's been forgotten here is the requirement for daily incremental delivery of records in 6725D. The requirement is that particularly when an immediate disclosure request comes in, that records need to be provided when they're available. So if there are pages of this report, this online report that was printed that didn't have redactions that were needed, then they should have been provided on a daily basis. Instead, they made Mr. Hartz wait the full 24 business days, I guess, to get any of the records. I think that's a violation. that daily incremental delivery did not occur. I don't think it's good faith. I think plus what you're basically agreeing is that you're allowing the city attorney to invoke 2 extensions on immediate disclosure requests. First, you have the 10-day extension, which is understandable. Remember, that's a maximum. That's if they need all 10 days, and then they're jacking on to that the other extension that's available for the other kind of public records requests. So I don't think they're acting in good faith in that manner. Nonetheless, they didn't provide records as they were available on a daily incremental basis, which is required under the ordinance. On the issue of anonymity, I actually agree with Mr. Dorsey. I don't think that, if you want to speak in public confidentially, that's fine. But when you file a complaint, unless there's retaliation, which unless there's some proof that there's going to be retaliation for filing the complaint, the public has a right to know. And it disturbs me greatly looking at your meeting packet here. Frank Darby in the clerk's office has continued to, invoke this mass redaction in your meeting packets. What you've said are not correct. That redaction should not be happening in your records. And you just let the clerk staff continue to redact information in these records. The public has a right to know. We've gone through this. I can file a sunshine request on this data right now and it will have to be provided. It's a waste of staff time when there's budget issues involved the city to be having people redacting information that the public has a right to know and should know. You should see it as well. And I strongly am against this whole concept of people being able to redact things and not let the public see it. If Mr. Hartz didn't want this information provided, then he should not have provided it in the first place. When he chose to provide it, then he's basically waived the information, and it should be provided.
Thank you. Additional public comment? Seeing none, public comment is closed. Comments on the pending motion? Member Nee?
Yeah. Well, I agree that the voluminous nature of the information requested and the fact that it had to come from multiple sources might require additional time. I think Mr. Crossman's point regarding the provision of information on a rolling basis does have some merit here. It should carry some weight. So I'm going to vote no on the motion.
Seeing no other comments, with respect to the rolling basis issue, my own personal opinion is that's very important where you're dealing with truly voluminous records, thousands of pages that have to be gathered, reviewed, and then released, where you're dealing with what is essentially 2 sets of documents that have to have redactions made and then reviewed by a supervisor. That's what's happening here. I mean, that's what I would expect is happening. These documents were given to a junior attorney or someone else in the office to review for redactions. Those redactions were made. They were then reviewed by a supervisor. They were then released. This is not, to me, the type of document that would lend itself to rolling basis production based on my experience as an attorney doing privilege reviews myself. But I totally understand if other folks would disagree with that. I do think that this was pushing the time limit. So I'm hesitant to find no violation here because this really did push the time limit. As Mr. Hartz noted, there was no specific reason given for the extensions, which is a violation of the sunshine. Once Mr. Hartz pointed that out, Mr. Dorsey then provided them, and I hope that won't happen again. I hope that Mr. Dorsey will endeavor to always provide an explanation as to why, a specific explanation as to why an extension is being invoked, and to provide documents when they're available as soon as possible. But no. No, Mr. Hartz, I'm afraid not, unless someone has a question. Notwithstanding my hesitancy, I still stand behind the motion. Member Williams.
I, like Member Nee, I'm against the motion myself, because no matter how voluminous it is, Mr. Dorsey has made it plain that there seemed to be some kind of interaction, personal interaction going between him and Mr. Hurst, and that sets the tone for me. And when you have an interaction going like that, that could have a difference in your opinion. So I think it wasn't given to him, yeah. So I'm against the motion.
Thank you. Seeing no further comment, call the roll, please.
On motion not to find violation, Member Nee.
No.
Member Nee, no. Member Cawthon. Member Cawthon excused. Member Washburn.
Aye.
Member Washburn, aye. Member Knebber. Aye. Member Knebber, aye. Member Johnson.
No.
Member Johnson, no. Member Chu. Member Chu excused. Member Chan. Member Chan absent. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams, no. Member Craven.
Aye.
Member Craven, aye. Madam Chair, we have 4 ayes and 3 noes.
The motion fails. Seeing no further motion, no action will be taken on this complaint. I thank the parties for their time and the interesting issues. We now move on to the next item, item 10. Before this item is actually, it's 5 o'clock, or it will be momentarily. So I would like to actually call for general public comments at this time. Number 19, if you could call.
Item number 19 is public comment for items not listed on the agenda.
Hi, members. Kimo Crossman. I wanted to just call your attention to the fact that on the agenda today are 2 items regarding electronic records. And in fact, if you think about it, the item you just heard also involved timesheets that were electronic records. And earlier this year, there was an interest in a move to develop an ad hoc committee to deal with electronic records in the city, particularly with regards to retention of electronic records. The clerk of the board submarined that and said she doesn't have the staff to do it, even though it's required by her to support the SOTF, and even though she didn't know how many times the ad hoc committee would be meeting or what the duties were, she said it proactively. She said she couldn't support it. No negotiation happened. She said no. But nonetheless, the decision then was to bring the issue of how to deal with electronic records in the city back to the CAC. It's my understanding that as of even today, still there have been no additional discussions on that matter at the CAC. I'll point out to you that there's ongoing lawsuits against the White House, 2 lawsuits against the White House regarding emails and deletion of emails and retention of emails. So this is an issue that has importance at a national level, and if San Francisco considers it a high-tech city, you would think that there would be an interest and a desire to deal quickly with this issue. I have sent a proposal to the CAC on how to try to deal with electronic records, at least emails, for just this task force. So the idea was not to embrace a citywide electronic record solution, but here's an approach that could be attempted at the task force level, and then look at how it works for possible recommendations for rollout more broadly. There's been no action on that I'm aware of recently, and I would just encourage that you deal strongly with this, because as you'll hear later in this meeting, the issue of retaining electronic records is an ongoing and difficult matter. And so I hope that you will take that seriously.
Thank you.
Members of the task force, my name is Francisco da Costa. I've come before this body before, mostly to defend the rights of the constituent when it comes to fair play and justice. And in the course of the last 10 years, again and again, some of us have had very serious problems with the city attorney's office. Now, here in San Francisco, we are fortunate that besides the task force, we have a circle of volunteers who deal with Freedom of Information Act, Privacy Act, and so on and so forth. Listening to the deliberations today, I feel that this task force must step up and do the right thing. In most cities, you really don't have an interaction, an educated expertise between the task force and constituents, and some of them will testify today, who help you, who help the task force. But there's a disconnect between the task force and the city attorney's office, again and again and again. So we'll be testifying later on in a case that has adversely impacted thousands of people. And not everybody can come here and testify. And not everybody has the ability to understand issues. And not everybody is well versed with the Freedom of Information Act and the Privacy Act and the Burton Act and the Public Trust Act and so on and so forth. But some of us do. And we try our level best to come here, not only before this body, but other bodies, but again and again and again, a culprit in this city hall is the city attorney's office. Thank you very much.
Thank you.
Ray Hart's not anonymous. I would like to first point out that I think it's really inappropriate to take action on any item when it becomes basically clear that the members of the board have not reviewed all of the relevant documents. And in that particular case we just did, you hadn't seen it and you didn't even know it was in there. And you made a decision based on what I was saying, that what was produced was inappropriate, and yet you still went ahead and found no violation. And I also find it very inappropriate that you will take the recommendation of the deputy city attorney against the public information officer for the city attorney when there is a direct conflict of interest. Mr. Lorente and Ms. Sanchez both work for the city attorney's office. They work 20% for you and 80% for the city attorney. They know which side of the bread their butter is on. Whose side do you think they're going to take? It is a clear conflict of interest, and it is inappropriate that someone in the city should have to come up here and be put in the position of having to fight a board which takes the advice of the very agency that is being complained against.
Thank you. Additional public comment? Seeing none, public comment is closed. We now move to item number 10. Could you please call the item?
Item number 10 is the determination of jurisdiction on complaint filed by Joshua Ark and Eric Brooks against the Public Utilities Commission for violation of 67.21 and section 67.29-7.
Thank you. And before we hear this matter, I will ask to be recused without objection. This is a matter before the Public Utilities Commission. As previously stated, my spouse works for the Public Utilities Commission, and I have been recused in the past without objection because of the appearance of bias and the conflict of financial interest. So I would ask again to be excused. Without objection. And I will therefore turn over the running of this item to Member Nee, who is the chair of the Complaint Committee. Compliance and Amendments, I apologize. Thank you.
Before we proceed, in the interest of disclosure, I should inform the gathering here that I am personally acquainted with one of the complainants, Mr. Brooks. I do not feel that that will prejudice me in any way in this matter. However, I would ask that if Mr. Brooks or the respondent has any problem with my presiding in this matter, they should speak now. Otherwise, I shall do so. Seeing no objection, let us proceed. Member Williams?
Yes, I would like to make the disclosure that I am familiar and have been following this, and I am familiar with the people that's bringing it forth, but I don't see where that would precede me from voting.
You feel no prejudice?
I don't feel any prejudice, but I do want to make it clear that I am aware of this, and I live out in this area, so I do have a stake in this area. In this, you know, I have feelings, strong feelings about it. So if the board, I feel that I could do it, but I do have strong feelings.
Well, then perhaps recusal is advisable.
I have strong feelings.
In that case, we would lose a quorum.
2, 3.
But you have to follow your conscience regardless.
Well, my conscience would be with the complainants.
Well, there you go.
In that case,
I'm telling the truth.
in that case, we have. I think we have no choice but to continue this matter.
I agree.
As your counsel,
Okay,
I
we
was-
have somebody in the audience who wishes to address the matter. Approach, please.
Yes, task force members. My name is Joshua Arce, Executive Director of Brightline Defense Project. I'm one of many complainants, one of 2 named complainants, one of many complainants. And seeing that there's no quorum, seeing that this is headed for a continuance, I'm going to ask that the task force embrace and utilize its power to request that an actual member of the staff involved with the I think we already have from the response from PUC staff the admission that emails were deleted. So I'm going to ask that the task force request the presence of the people that deleted those emails so we can have a productive meeting the next time.
Okay. Well, under the Sunshine Ordinance, sir, the respondent is required, this is under 67.21E, I believe, respondent is required to send a representative who is knowledgeable in the matter at hand. So the request is, I mean, your request is granted by law, let's put it that way. Please be seated.
Sure.
Okay. All right. The chair is going to rule that.
No.
Ma'am, please be seated. Please be seated, ma'am. The chair is going to rule that this matter is continued without objection.
Very good.
Done.
All right.
Thank you all for coming.
No public comment because this issue has been continued, but I do apologize to the members that showed up. Because of sickness on behalf of some of our members, we do not have quorum. It happens from time to time. Actually, this is the first time I think it's happened
I've never seen
in the 5 years or 4 years I've been on this board. So I do apologize to the members of the public and the people who've showed up for that item, but we will continue it.
So is there not time for just a question for clarification?
I'm afraid not. If it's a question about scheduling or what have you, you can talk to Mr. Rustum. You can talk to Mr. Rustum offline, not in this meeting.
No.
Not in this meeting. Afterwards, I'm sorry.
I thought you dismissed the meeting.
No, just
No.
the item, ma'am.
Just this item.
I apologize. We're now on to item number 12.
Item number 12 is the determination of jurisdiction on complaint filed by Anonymous against the Police Commission for failure to maintain an index of records.
Members, I move that we find jurisdiction on this item.
A second.
Is there any public comment on the narrow issue of jurisdiction? Seeing this is jurisdiction as to the item about item number 12 only. Seeing no public comment on the issue of jurisdiction, can we call the roll, please?
On jurisdiction, Member Nee.
Aye.
Member Nee, aye. Member Cawthon excused. Member Washburn.
Aye.
Member Washburn, aye. Member Knebber.
Aye.
Member Canepa, aye. Member Johnson. Aye. Member Johnson, aye. Member Chu. Member Chu excused. Member Chan. Member Chan absent. Member Goldman.
Aye.
Member Goldman, aye. Member Williams.
Aye.
Member Williams, aye. Member Craven.
Aye.
Member Craven, aye. Madam Chair, we have 7 ayes.
All right, and I would note before the complainant and respondent discuss this issue that there is essentially no information in our packet except for the jurisdictional memo and a response from Daniel Mahoney, but that the advice of our city attorney or the analysis of our city attorney, Mr. Lorente, is that this complaint relates to and is essentially the same complaint as was heard and decided in 08056. That order of determination was inadvertently left out of the packet, but has been provided by Mr. Restom today. Is that correct?
It's in the packet.
It's in the supplemental packet that was provided, and members of the public should also have access to copies. That was the order of determination dated January 6, 2009. That being said, I will proceed with this complaint, and we will act if necessary. So I would invite the complainant, anonymous complainant up. The anonymous complainant has 5 minutes.
Just to start this out, all my complaints from now on will not be anonymous. However, I would suggest you take the little phrase at the bottom of the complaint form that says if you want to become anonymous, you can. It's kind of ridiculous to put it on the form and when someone chooses to be anonymous, then say, oh, you can't do that. It says right here, notice personal information, da-da-da-da-da-da. Okay. The reason that I filed this against the police commission is for a couple of different reasons. One, if you go to the police commission's website, it says that the police commission, the mission of the police commission is to set policy for the police department, not the other way around. And basically what I'm saying is that if you look at the index of records statute or the section, it says specifically on 5 different occasions that each department, oops, I should get it and read it. Departments, agencies, boards, commissioned, and elected officers. Each department, agency, commission, and public official shall. Each department, agency, commission, and public official is encouraged. Each department, agency, commission, or public official of the city or county are prepared and maintained. And changes in the department, agency, commission, or public official practices. So basically, it delineates very clearly that there are requirements for each of those. And I don't think that because the police commission chooses to have the police department handle the administrative functions, releases them from the responsibility of complying with the law, any more than it would release this task force from complying with the law by saying that the board of supervisors or the clerk of the board does something for you. The police commission is responsible for seeing that its particular operations comply with the law. I would also question the response of the police department. What they do is they note 2 things. They note here the police commission secretary. Well, obviously, the police commission secretary against whom the complaint is filed is going to say no. And then it lists city attorney Molly Stump. So here we have another case where a deputy city attorney is giving advice which is in conflict with what I believe is the law. And if you actually look at the section regarding enforcement, it says that the city attorney shall not act as a counsel for any employee who is attempting to prevent access. And if you look at another section of the index of records, it says the purpose of the index of records is to provide the public access. Therefore, both of the people that they relied upon in making this thing, saying that the police commission is a part of the police department, have vested interest in saying that. So really, I don't think there's any basis. I think the police commission in and of itself is a separate entity. The index of records says that commission shall maintain the index of records. The simple fact that they choose to have these police force do it for them is no justification for it failing to be done. That would be like saying any city agency who hired an outside contractor, if the outside contractor failed to do the job, the city was free of all responsibility. And when we had the original complaint, to which this is amended, it basically, the whole presentation by Mr. Hart, or Lieutenant Hart, was the fact that, oh, well, we have to have permission from the police commission to do this. So it gets into one of these finger-pointing things where one's pointing to the other one saying, oh, no, it's their job. No, it's their job. I think both of them, whether one or the other or both do it, are both responsible for their individual department or commission. I think the San Francisco Police Department has a responsibility. They have not done that. They were found in violation. And I think that the Police Commission has not done it, and they should be found in violation. If they, however they choose to do it is irrelevant. How much time do I have left?
Through the chair, 44 seconds.
4 seconds?
43, 41, 40.
Okay. I also want to say that the memorandum from the city attorney that basically simply corroborates the same thing that Molly Stump, who is the city attorney that represents the police department, said. There's a clear conflict here. You know, basically we get these issues where if it involves the police department, you get the DCA for the police department who says no. If it's the Board of Ethics, the DCA for the Board of Ethics says no. If it's this task force, the DCA for the task force says no. And, you know, how much of a conflict, you know, becomes totally insurmountable?
Thank you. Is there a representative here from the Police Commission to respond? I note that in their email they said they would not be appearing. Seeing none, I apologize. Is there anyone here to present facts and evidence in support of the complainant? Seeing none, there's no one here on behalf of the Police Commission, therefore the matter is with the task force. Member Nee.
Yes, a couple of things. First of all, on the substance of the complaint, I feel that, you know, the Police Commission and the Police Department have had plenty of time to fulfill the requirements. You know, the requirements have been up there since 1999, Prop G. To me, there is no excuse for their failing to get this done. Second thing, notwithstanding the feeling that they don't need to attend, I disagree on that. 67.21E is quite clear on that. So at the very least, we have a violation of 67.21E.
Motion.
No, it's not time for motions, but I think it will be. Any other comments?
I do have, I mean, this is a sticky question for me. Is the Police Commission separate from the Police Department? I do, in a lot of respects, I do see them as a separate entity, able to hear, to be able, this complaint to be brought against a separate entity. I think that's what this rests on for me. Because, I mean, just because it's the Overseas Board doesn't mean that, yeah, they're doing it, it's fine. So I don't know, I have the feeling that this could be also a violation.
Seeing no other comments, I will say that I too think there's a violation here. Even if it can be concluded that administratively the Police Department is responsible for the Police Commission's records, it appears that it wasn't until Mr. Hartz pointed out that there's nothing up there for the Police Commission that the Police Department said, oh, well, yeah, we'll include that. But not only that, then they go on to say, oh, but wait a minute, it appears that there's a different entity, the Office of Citizen Complaints. The OCC does not have their records listed as required the admin code section, but the OCC is a separate entity. Their records will not be a part of the police departments and should be handled as a separate matter. So first they're saying, it's just almost nonsensical to me. First they're saying, oh, well, the police commission is under the police department, but then there's a separate entity that's under the police commission that's not under the police department. I mean, I understand legally that the Office of Citizens Complaints is a different entity that's charged in response to take a position sometimes contrary to the police department. So I understand why they may feel like it's a separate legal entity. But for purposes of this provision, either it's all covered under the police department's records, or, it's their responsibility to see it's done. So, or they're different, and they're each individually different. The commission should have been responsible for its own and its subservient entities' records. So I do think there's been a violation on behalf of the police commission here. And I would support a motion finding a violation consistent with the prior one, which is 6729 and 6721E, as Member Nee points out. Seeing no further comments by the task force, I would note that because the members of the task force did make comments, I will offer Mr. Hart's 3 minutes for clarification if he needs to.
My primary objective in doing this is not to cause any of you extra work. It is the simple fact that I have, in the past, just simply walked the circle and watched the number of manipulations that are done to avoid this and to shift positions, and then 6 months later nothing's done, and it's like, oh well, it wasn't our fault and it was supposed to be them, and we made that clear before when they really didn't. And I really do feel that the police commission oversees the police department. And if the police department is in violation, it should have been the police commission that made them do what they were supposed to do, for which they were found in violation in the first place. They're separate entities. And now that we have this third entity coming into the mix, I think they all really have their own. But I've told you before, I was in the military, and there was one thing you cannot do. You can delegate a responsibility to someone, but you cannot abrogate your own responsibility for seeing that it is done. A captain of a ship cannot give orders to the crew, and if a crew member fails to follow the order, simply say, well, it wasn't my fault because I told him to do it, he just didn't. The captain maintains the responsibility. The police commission maintains responsibility for ensuring that it is in compliance with the law. And simply saying that because they gave it to the police department dropped it, that they're not responsible is not, I think, a justification. And I do believe that it is important to have them both found in violation to ensure that the necessary actions are taken. Because as Member Nee mentioned, it's been 10 years. And their argument in the first case was simply, oh, well, we didn't know. And, I can see that going on ad infinitum.
Matters with the task force for a motion and deliberation.
Madam Chair.
Member Nee.
Yes. Just one other comment I'd like to make before making the actual motion. In the letter or email from Daniel J. Mahoney, he says in the third paragraph, the police department is currently undertaking action to correct that violation, and the records of the police commission will be included. There is no indication here of when the police department expects to complete this task, and that would have been something I would have liked to ask the police commission representative had he or she been here, which is one reason I think it's a good idea to find 6721E among the violations. I move that we find violations of 67.29 and 67.21E.
Second that.
No further deliberations by members. Public comment?
Hi, members. Kimo Crossman. I want to say thank you to Mr. Hartz for taking on this difficult issue of getting records and information from the police department. They're notoriously difficult to get information from. And thank you to Mr. Hartz for identifying that the index of records that the Sunshine Ordinance requires is more extensive than the retention schedule that's being used by all departments in the city. It has requirements, this index records has requirements for, under what manner of organization the information is accessed, by reference, by name, date, proceeding, project, so forth. There's a lot more information required in index of records than what the city is using citywide when they just list a retention schedule online. Nonetheless, I think my understanding is that policy bodies set policy, and then departments do the work. And I don't think there's any harm in finding the police commission in violation, but the reality is police commissioners don't create a index of records. They set a policy saying our policy is the department follows sunshine, and then the department, through the department chair or the department head, implements that. So it's fine. Find a police commission violation, but the reality is really the buck generally stops at the department head or ultimately the mayor, since they all report to the mayor. The policy body just sets overall policy that they're prohibited by the charter from getting involved in day-to-day matters of departments.
And any additional public comment? Seeing none, perhaps a friendly amendment to Member Nee's a motion. I would say that the motion should read that the task force finds the commission in violation for failure to ensure that its records have been included within an index of records as required by 6729, to make it clear that it was their failure to ensure that their records, whether listed separately or together with the police department, but it was their failure to ensure that that was done.
Maker accepts.
Second accepts.
May I just one comment?
Sure.
Yes. I think it should be clear that the respondent, the listed respondent in this complaint, is the police commission. So I think that's the party that should be addressed in this motion in terms of the violations.
Seeing no further comment, please call the roll.
On the motion, Member Nee.
Aye.
Member Nee, aye. Member Cawthon excused. Member Washburn.
Aye.
Member Washburn, aye. Member Knebber.
Aye.
Member Knebber, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chu excused. Member Chan absent. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams, aye. Member Craven.
Aye.
Member Craven, aye. Madam Chair, we have 7 ayes.
Thank you. And that, at the call of the chair, will be referred to the same entity as to the prior complaint, which is the Education, Outreach, and Training Committee, to work with the police department to make sure those records are listed. The next item, please.
The next item is the annual report to the Board of Supervisors.
I would move that we continue this item to the next meeting because Chair Chu, I believe, has been the primary person working on this item. She's unable to attend. Unless there's someone else here today who has been working on it that would like to comment on it in terms of members.
I second your motion.
I think we can continue without objection.
However you want to do it.
I would, before it's continued, I would say that we've had the opportunity, it's in our packet, each of us have had the opportunity to look at that to the extent we have typographical or substantive changes, to please forward them to Chris for the public file and also Chair Chu to take those into considerations. That will help us hopefully have a more final version at the next meeting to consider. Item 15.
Item number 15 is a report from the Complaint Committee meeting of February 10th.
Members, at our last meeting, the major thing we did was discuss whether the administrator should be able to weed out, if you will, items coming before us that aren't pertinent to the Sunshine Ordinance. After some deliberation and with input from various Sunshine advocates, we decided that everything should come before us and that we should weed it out, not to have a gatekeeper at the administrative level. So there you have it.
May I follow up? I guess my question would be, would it not be possible to have as a gatekeeper the complaint committee?
Well, yeah, that's what I mean. We would
Okay.
be, as opposed to having the administrator get with the city attorney and decide whether or not something is or would not sunshineable. It should all come to us, even if it's just on its face, just wacky.
I just wanted to clarify who the us was. I would have confidence that on an issue, is the question was, is this even something within the possible scope of the Sunshine Ordinance, that the complaint committee could, definitively rule on that, subject to being overruled by the full task force. So I think that would be something they could do. DC Laurenti, is that?
It's true. It's been done in the past. There have been situations where the complaint committee has found no jurisdiction. It was appealed to the full task force, and they had a hearing de novo and found that it was worthy of consideration. So, yes.
Now, that's it. Concludes my report. Unless other members of the committee have something to add. No.
Public comment on this item?
Seeing none.
Seeing none, that item is closed. Next item, please, Chris.
Item 16 is the report from the Education Outreach and Training Committee. Madam Chair, before the meeting started, the chair, Sue Cawthon, notified me about noonish that she would not be able to attend and requested that Member Washburn or I read the report that she had provided.
Member Washburn, would you like to do the honors?
Sure. The EOT committee is working on a revised mission statement to reflect our new focus on community outreach and departmental liaison. We discussed our work plan and goals at our January meeting, and we're set to finalize our new mission statement in February. However, we did not have a quorum. Instead, we had Lieutenant Daniel Mahoney from San Francisco Police Department. He heads the legal department, the entity charged with open government responsibilities. We therefore held an informal discussion on police department sunshine issues. However, we did not convene a meeting or take official minutes or any binding action. We're working with Lieutenant Mahoney on enhancing the sunshine process at the police department. We have asked for an appointment of a custodian of records and sent Mahoney a copy of the SOTF's PowerPoint presentation explaining the Sunshine Ordinance. He intends to use this in a presentation on open government he's preparing for department officials. Assigned last June to the legal division, Lieutenant Mahoney is putting together an index of records and has agreed to meet further with the EOT committee to discuss sunshine issues.
Thank you. I would ask, I read also the update that was in our packet that had bullet points of some of the issues the committee discussed with Lieutenant Mahoney. And it's my understanding that the issue of also their compliance with the index of records was the main reason that they were referred to EOT based on the order of determination from the last hearing and based on the order of determination that will emanate from this hearing. Also, the issue will be the police commission's records included in a separate index or in their own. So to the extent that that can be made clear and be made a focus of at least part of the future EOT, I think that would be good. Public comment or any member comment, first of all? Seeing none, public comment?
Hi, yes, Kimo Crossman. I was on my way up, but I heard something a little bit concerned me. So this was an informal meeting. It wasn't a formal meeting because of quorum issue. Is that? I'm guessing that was the issue.
Right. We only had 2 members present.
Okay. Well, I would just, I would just say I hope that it was that there's been times that people arranged scenarios like that so they wouldn't have their remarks recorded, and I hope that that when a scheduled meeting occurs, notice the meeting occurs, that it is tape recorded as is required, and that if it's not going to happen, that the meeting be canceled so that people can observe either real time or after the fact.
I'd like to give some clarification, if I can, through the chair.
Yes.
What you have on page 273 is basically a summary made by your assistant administrator who reviewed the tape. There was a tape made of this, and this is a summary of that. And this was just informational, and it's provided that we can obtain information and present it to the body for further consideration, and that was done. So everything was done appropriately.
Member Williams?
I called in, and I was told that there was not going to be a quorum. by our administrator. And I was not advised that there was going to be an informal meeting at all, because I could have come to the informal meeting, but I was told that there was not a quorum.
There was some confusion that day. I received a call suggesting that there wasn't going to be a quorum, and so I wasn't planning to come. And then I got a call saying that there was going to be an informational meeting. I believe the issue was that the Lieutenant Mahoney was planning to come, so rather than cancel at the very last minute, I was asked to come for this informational meeting.
Who was the member that wasn't present that would have caused the lack of quorum?
I think it was me. I got sick that day.
Okay. Okay, well, it sounded like there would have been quorum at 3 members shown up. So in the future, maybe we can just try to avoid that happening and maybe be more consistent. It sounded like it looked like there wasn't quorum, but then there was going to be, but then there wasn't.
Yeah, it was quite confusing.
All right. So we apologize for any inconvenience, or I would, through the chair of the committee, to members of the public, but hopefully that will be avoided in the future. Any further public comment on EOT?
Yes, since that pertained to the police department, I do believe that the lieutenant that did show up, since he's relatively new, showed a cooperative attitude. And I really appreciate the fact that the task force has passed the letters of determination, because I think without the pressure, there's really little incentive for them to comply with the public records law. Over the last couple of years, I've made numerous attempts to get records from the police department, and they asked me terribly inappropriate questions like, why do you want it? And then if you actually told them why you wanted it, they would simply hang up on you, swear at you. And I've even had the office that they told me I should call, which was the office who sent the representatives, and the only person I could get to talk to me was the woman who is the, staff secretary. And she asked me to call back later. She said basically, I'll talk to you, but I can't talk to you when the officers are in the room. So I really feel that having this on there will not only allow the public access to the records of the police department, the Office of Citizen Complaints, and the Police Commission, it will also protect city employees from being put in some sort of an awkward position where they know what the law is but are afraid to to enforce it or to participate in it because of possible negative reactions in their job.
Thank you. Seeing no further public comment, no member comment, the item is closed. Next item, please.
Item number 17 is a report by the Compliance and Amendments Committee for the meeting of February 12th.
Okay. I have a few things here. First of all, the minutes are basically an accurate reflection of what went on. I want to call the task force's attention particularly to item number 4. It provides a good update of where we are on the amendments to the ordinance. Member Craven did an exemplary job of reviewing what we have in Articles 1 and 2, providing footnotes. Very, very helpful. And that work will continue as is indicated in the minutes. In minutes item number 8, I believe that should be corrected to reflect merely that I made an announcement, and I have already corrected that in minutes that I sent to Mr. Rustum. I would like to invite everybody, but unfortunately these recessionary times just won't permit it in my own budget. So anyway, I do hope that all of you will attend, and if any of you want additional details about it, you can see me after the meeting is over, and I'll be happy to give you some pointers on where you can find additional information. One other thing, I have received personal communication from a member of the public asking about where we are in formulating a set of guidelines regarding the task force's own electronic records, the retention, storage, retrieval, etc. I explained that, other work by the task force and by the Compliance and Amendments Committee has really prevented our proceeding as quickly as we could. The corresponder said, that's fine, but it's been 6 months. So I would like to have that put as an agenda item for the next Compliance and Amendments Committee. I do agree that 6 months is a bit of a long time to wait. I think there's been kind of an agreement among us that while we are trying to determine best practices in other jurisdictions toward a general policy affecting all city departments and agencies, there's been an agreement, I think, that we should at least adopt guidelines for the task force itself, kind of as a leadership by example. So with that, I would like to again request that this matter be put on the agenda for the next Compliance and Amendments Committee meeting. I would ask if Committee Member Johnson or Committee Member Craven has anything to...
Because I made a commitment to them to do a PowerPoint presentation, and I spent about 4 weeks working on it, and I was really torn because I had a problem deciding whether I wanted to present a PowerPoint presentation reflecting what the task force is able to do today, as opposed to what we ideologically would like it to be able to do. And I would like to recommend that the two committees, the Compliance and Amendment Committee, who is working on the changes to the Sunshine Ordinance to make it more effective, work with the Education and Outreach Committee more on what the changes that are needed to be made to make the law effective, and then going out into the community and soliciting support from the League of Women Voters and other organizations to help get that on the ballot and to support it so that it will pass. Because I was really torn. I didn't want to go out and what's the old expression, blow wind up somebody's skirt and say, oh, sunshine's great and it'll do this and this, when we, I think, all know that there are some real concerns about particularly enforcement. So my suggestion is put the energy, rather than into focusing on telling people what it is right now, focus on the changes that you perceive going into the next election, and then focus on what changes those are, what they would do to benefit the citizens of the city of San Francisco, and what these organizations you're presenting to might be able to do to help move that forward to get Sunshine really where I know all of us would really love it to be.
Thank you. I will allow Member Williams to make a comment on this.
I just wanted to go back. It's up under Sunshine, and then, of course, up under Education. Seat 4 has been vacant for so long. Is there some kind of way that the Education and Outreach Committee could look for a person? And what kind of advertising have we done? This has been a vacancy for an awfully long time.
Seat 4 is the member
journalist
nominated by the New
from
Media.
the New Media.
New America Media.
New America Media.
Yeah.
If the EO2 would like to contact, is Sandy Close still the director, Member Nee?
To the best of my knowledge, yes. As a matter of fact, I popped an email to her just today to try to give her a gentle nudge to try to get the appointment, move the appointment forward.
Right, but if any member of the task force, member of the public, knows a member of the emerging media, I think it's called, also, formerly known as minority media, who might be willing to serve, I think that person should be brought to the attention of the chair and the administrator, and through Member Nee, perhaps Ms. Close, so that we can provide more candidates. I mean, we don't need to wait for Ms. Close to act. If we have a candidate, we could have Ms. Close nominate them. So I would say if you know of anyone who would be good, contact Member Chu, Mr. Rustum, and Member Nee, and get the ball rolling. It'd be great.
Okay, one more question. Down with the ex officio, Mr. Scarl, they replace
Harrison Shepherd, and he has passed away.
Yeah.
We mentioned it at the last meeting. Yeah.
Really? And that really threw me. I mean, that's why I'm kind of off, because I thought, I mean, you know.
He was a very
Yes, he
well-known
was.
member of the community and a great public servant, it appears. So hopefully we'll, at the right time, hopefully soon, get another ex officio member appointed by the mayor's office.
Maybe Ray Hart's, Chemo Crossman.
All right. Any other comments on the administrative report?
I hate to hear that.
I mean, excuse me, on, we're not there yet. Next item, please.
The next item is the administrator's report. Madam Chair, I have a question on what do we do with the Peter Witt's communication regarding 08053
This is the communication from Mr. Witt.
from Mr. Witt.
Why don't you give your report, and then we'll deal with that at the conclusion of your report.
The report is as it is presented in the packet. No changes there, except for we have two more items from Mr. Hart's, from which I need the originals because the fax isn't clear.
Oh, you will follow up with Mr. Hart's offline and make sure we have them, so they're scheduled.
So that concludes my presentation.
Thank you. I would note on the first issue, with respect to the complaint log, I'm not sure it's quite accurate. So, for example, on the 08051 Paul Horcher, you have it reading violated 6721A and C, no further action, but that's not correct. It was referred to EOT. So that should be changed to, instead of no further action, it should be referred to EOT. Similarly, with the next one down, 08052, Mr. X, instead of no further action, it should be referred to compliance and amendments. With respect to 1-2 down, anonymous tenants versus building inspection, that's correct. With respect to Chemo Crossman, 08055, it should be, instead of no further action, it should be violation was found, if I recall correctly, and it was referred to compliance and amendments. So you just need to insert the sections violated. And with anonymous versus police department, that should also be, instead of no further action, it should be referred to EOT. There was a violation and it was referred to EOT. So if we can be a little bit careful about those. And also, I noted that as an omission, at least I believe it was an omission, Mr. Rustin did not include the prior orders of determination in the administrator's report, which we usually have, so that the task force can see the actual order that came out from the last hearing. And we will endeavor to do that for the next packet. I would also note that we have in here a response from the Department of Building Inspection in response to the failure, really, of the task force to find a majority vote. If you remember, there was a motion to find violation failed, the motion to find no violation failed, but they did submit to us some additional information, including, as Member Cawthon, I believe, wanted, the record retention schedule and the matrix, which helped them establish their fees for public records. So I just wanted to note that that was in our packet, and I appreciate the department following up on that, providing us that information. And finally, did individuals have a chance to read the submission from Mr. Witt, which is at the conclusion of the administrator's report? As you recall, there was a complaint filed in the task force. There was a split vote. Some members of the task force wanted to continue the matter so that a member of the Tax Commission could be present. The majority of members felt that the complaint itself was flawed, it wasn't decipherable, and therefore decided to take no further action, but encouraged Mr. Witt, if he had additional complaints, to refile a more specific complaint based on limited information. And I believe that this correspondence included here is Mr. Witt's attempt at doing that. So, Member Never, I always pronounce your name wrong, I apologize. Pronounce it for me one more time. Knever. It's Knever. Member Knever, do you have an opinion on what we should do with this? and this is not an action item, so it's really a discussion as to how we feel the administrator should handle this.
I was actually, I mean, I read over this a couple times, and it's still a bit, I don't know. What he wants is just to be recognized. I mean, that still it's the same stuff over from before. I don't think that we can do anything with it. I think that the complaint has to be put up again, right, before we can act on it. And that's my understanding.
There either has to be a complaint, or if it is of conduct that's violated the ordinance, if it's a motion for reconsideration as to prior complaints that were either upheld or rejected, I guess it could be a motion for reconsideration of a prior complaint that was rejected, or it could be a motion to, I guess, revisit or provide enforcement on a prior determined complaint. I don't know. Mr. Lorente is looking confused. I'm not sure we've done that before, but there are ways of bringing this to our attention, but it looks like it's still unclear as to how we would handle this.
Yeah.
Mr. Lorente?
Well, the vehicles are a motion to reconsider based on new information that was not available at the time that the case was initially heard. That's the normal process. Or the person could file a new complaint. But if it's a matter that has been heard and there isn't anything new, but the complainant is not satisfied because he doesn't believe that his issues were fully aired out, I'm not exactly sure what needs to be done here. I think that he had a complaint that was sustained. It was referred to compliance and amendments. There was an appearance by the director of the Taxi Commission who made representations about what they were doing to try to change the procedure to make it more sunshine friendly. And then Mr. Witt filed another complaint alleging a time when this process was not yet implemented and wanted to be heard on that. And I think that was what was the last matter that was heard before this commission, this task force, excuse me. So I'm not sure exactly what he would want you to do again at this point.
I mean, from reading it, I think what he wants is to see the old logs amended, and I don't know if that is within our jurisdiction. It's not. We can find that they violated part of the Public Information Act or the Sunshine Ordinance, but we can't force them to go back and put these things back in. At least that's my understanding. And once we found determination on that prior violation, we can't keep finding violations on the same thing in the same insertions. I mean, correct me if I'm wrong.
No, the Sunshine Ordinance does not require a department to create a new document. For example, if there was a violation in the minutes because the material was missing, we could say there was a violation in the minutes. You haven't provided the information that's required. Go forth and next time include that information. I'm not sure whether we could require them to go back and amend minutes if that had been proven that there was an error made. That's kind of almost more akin to a Brown Act requirement that, for example, things decided in a public meeting that was illegally noticed or didn't have quorum would be null if you brought a Brown Act violation. But again, we don't have those powers to null actions taken by departments for alleged violations of Brown Act sort of things. So I'm really kind of at a loss. I guess, is this unfair? I would ask that this be brought to the attention of Chair Chu, and that, because we can't really take any action here, and that Chair Chu can review this and perhaps work with Mr. Rustum to maybe have a meeting with Mr. Witt to go over what sort of powers we do have and what sort of things we can do, and if I could request that maybe Mr. Lorente participate in that meeting. I know this is something we've done before. Administrator used to meet with complainants and say, try to basically help them understand what we can do, what we can't do, and how to best present their complaint to us. Therefore, get the minutes you say are missing the information, submit that as a concise exhibit, those sorts of things. So that's what I would suggest, is that if a meeting can be held between Chair Chu, Mr. Witt, the administrator, and Mr. Lorente, I'm willing to try it once at substantial cost of time and see if it works. Member Knepper?
Because the idea is it's not really asking us to do anything. It's just, again, restating what he thinks is missing. So I agree with Chair Craven, right? We can try it and see what happens, and then go from there.
Because it does, there is, for example, there is something in here about failure to send a person to appear at the task force. So that arguably is something within our jurisdiction that could be the basis of a new violation if the task force so chose to do. So there are some things in here that might.
Yeah, but it's not. But he's not actually making a complaint about that. He is. I think that he's referring to past complaints that he's had and that we've already ruled on when he talks about that stuff. So to me, it's not clear that he's talking about, I would like to make a new complaint about because of this or that. It's just, this is what has happened before, and these issues are still not resolved for me, regardless of what the ruling is or whatever.
I don't know if this will be helpful, but if possible, if the chair could write a letter saying that in terms of what this task force can do, they tried to air out the issues. This complaint was heard. We heard from the department. There were some commitments from the department regarding changes in their process and procedure. It was prospective. It wasn't retroactive, and we don't have the power to make retroactive changes to what they are doing, but we have effected change prospectively, and if he, and hopefully those changes will be, suitable to him. If they're not, then you file a new complaint regarding those processes that were implemented. I think that's.
Yeah, or I think that is my suggestion, and this is all at the adoption of Chair Chu, would be to do that, to maybe write the letter in the first instance and then say if he would like to have a meeting with Chair Chu and with Mr. Restum and with you, that they're willing to do so. I think, that's something that we could do. So that would be my recommendation to Chair Chu. Mr. Restum, if you could let her know that we've asked her to consider that.
That's what happens when you don't show up at meetings.
That's right. That's what happens when you have the flu. Don't get the flu. Don't get the flu. All right. Did we take public comment on the administrator's report? I don't believe we did. Public comment on the administrator's report.
Officially, for the record, I'm not anonymous. I'm Ray Hartz, and I would like to make a formal request to all the members of the board, and to, in particular, Mr. Restum, that all upcoming agenda items with my name listed as anonymous be changed to Ray Hartz. If he needs to have the paperwork refiled, I am more than willing to do that, because I would like to see those folks come in and actually talk about the substantive issues in the complaint, rather than spending the time dealing with what I provide them, which is smoke and mirrors, where they can talk about everything but the issues at hand. I would like to correct one thing that the public information officer said to Mr. Nee, and you answered your question as to whether those records had to be gathered. No. The City and County San Francisco Index of Records lists there that all timesheets are online, and ergo those timesheets, which is all I requested, are there to be printed out. And I would also ask you in the next meeting, since that will include the lack of substance or lack of responsiveness to that same request, that all of you take the opportunity to look at the 149 pages and see what I got, because what I got was basically a whole bunch of blank pages. And then the excuse being, oh, it's voluminous.
Seeing no other members of the public comment is now closed. I believe that brings us to the end of the agenda. Move to adjourn.
Second.
Thank you.